Welcome to LexIcon, your visual guide to public international law. Today we will finally speak about sources of international law, but first a little bit of history. So in 1920, the League of Nations is established. It had its own judicial organ, which was called the Permanent Court of International Justice. After the Second World War in 1945, the United Nations is established together with its own court, the International Court of Justice, or the ICJ. And the year after, the PCIJ, the previous court, got completely replaced by the ICJ. And the Statute of the International Court of Justice, Article 38, contains sources of international law. It says, the court whose function is to decide in accordance with international law such disputes as are submitted to it shall apply. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. International custom as evidence of a general practice accepted as law. The general principles of law recognized by civilized nations. And finally, judicial decisions and the teachings of the most highly qualified publicists of the various nations. Let's begin with the international conventions, which are in fact treaties. Treaty is an international agreement concluded between states in written form and governed by international law. So, whether general or particular means that it can have any subject matter. Establishing rules expressly recognized by the contesting states, this means then when signing a treaty, states have themselves agreed to these rules. Here are some examples of the treaties that you definitely have heard of. 20th century, 1939 Molotov-Ribbentrop Pact, then the United Nations Charter, for example, the North Atlantic Treaty establishing NATO, or the Schengen Agreement. 21st century treaties, the Minsk Protocol of 2014, Paris Climate Agreement, or the Brexit Withdrawal Agreement. Let's now move towards custom. Evidence of a general practice accepted as law. As you can see, it has two elements. First, general practice, when certain practice becomes common among states. And second, accepted as law, when there is a belief that a certain practice is a legal obligation. This is called opinio juris. So we have a legal area of a problem, and let's say part of it is regulated by a written or a codified treaty. And so customary international law would govern parts that are not governed by a treaty. General principles of law. They're quite abstract in nature because the content is not written down and there is no precise list of such principles. But to give you some examples, good faith principle, that the conduct shall be honest and fair, respect for human dignity, that protection of human rights is an important principle of humanitarian and human rights law, principle of proportionality, that certain measures, be it court measures, punishment, certain interference, or anything else, shall be proportionate to the purpose that it aims to achieve. In fact, two approaches exist here. First approach provides that treaty law, customary international law, and general principles of law are all separate and autonomous. The second approach provides that the general principles of law are part of treaty law and customary international law. You decide which one you agree with. Finally, judicial decisions and the teachings of the most highly qualified publicists. Article 38 itself provides that these are subsidiary means for the determination of rules of law. So these are traditionally viewed as supplementary means used for interpretation, application, and development of law. There is a distinction between primary and secondary sources, and some authors claim that treaties and custom are primary and then the rest are secondary sources. However, the approach of the International Law Commission is that general principles of law also fall under primary sources of international law. Is there any hierarchy among these? No. Main or primary sources of international law are not in a hierarchical relationship among themselves. So treaty law, customary international law, and general principles of law are all equal. That is it for today. I hope this has been useful. If you have any questions, definitely leave them below, and I see you very soon.